Okay, folks, I think we can get started. Welcome to all of you here. There are a number of folks joining us on Zoom as well, so at times I'll be kind of looking up there. My name is John Schoenig. I serve here in ACE. I help direct our ACE Teaching Fellows program, and I also help lead our program for educational access. I'm joined here by Professor Nicole Garnett, who's a professor in Notre Dame Law School and a former professor of mine. We're going to talk about a case that was just released. We can talk about that later. We're not going to talk about her experience. We're going to talk about a decision that the Supreme Court just released its opinion on Tuesday morning, Carson v. Makin. So just very briefly, let me explain what's kind of the holding there, and then we'll have a conversation about what's happening. So the court was reviewing a very curious program that the state of Maine has had for 150 years. It's a town tuitioning program where essentially families can take advantage of state aid to send their child to a non-public school, to a private school, including private schools outside of the state. In 1981, they amended the provision governing this program so that the only schools to which families could not send their children were religious schools. This was challenged on free exercise grounds, and the court released its opinion on Tuesday in a 6-3 opinion that provision, the non-sectarian provision, violated the free exercise clause. So here's what we'd like to do. We want to leave plenty of time for folks both joining us virtually and you all here to ask questions. So I want to address 4 issues. The first is to kind of get the story of this right. And there's no one better to talk about the story of this than Professor Garnett, than Nicole. So we'll talk about both her experience with this litigation as well as the broader kind of procedural history, how this made its way to the Supreme Court. It's probably worthwhile to spend a good bit of time talking about what is probably the core principle in all of this. So the second thing we'll do is we'll talk about neutrality and what's kind of going on with neutrality in this case. I think it's very important. Then we'll really dig into the opinion itself, what the majority and dissenting opinions had to say. And then finally, we'll say a word about what's next, what's probably to come on all this. So Nicole, to start, can you talk about your history with this litigation and then kind of how it makes its way to the court? Because it's a long and winding road, both yours and the case.
So it's not just the story of the case, it's the story of my life. So I finished law school in 1995 and spent a couple of years. I was clerking, and then I started practicing law at a little law firm, public interest firm in DC called the Institute for Justice. And at the time I started, the first voucher programs, including religious schools, had just been created in Maine and not in Maine, in Wisconsin and in Ohio. And I really went to do school choice work. So this is what I wanted to do. Those programs were, I think the inclusion of religious schools in the Milwaukee program was challenged the day I started. So I threw myself into this litigation, defending the right of states to use public funds to give kids the option, if they chose, to attend religious schools. And at the time, in 1996, when I started, it was not clear that that was constitutional. We thought maybe it violated the Establishment Clause. So, it was all hands on deck. I was really involved in this litigation. But there was a parallel litigation strategy that some scholars, Michael McConnell in particular at Stanford is a great law and religion scholar, were encouraging us to take. And Michael said, well, why don't you also, while you're defending the inclusion of religious schools in voucher programs and school choice programs, why don't you find some programs that exclude them and take the offensive and challenge the exclusion of religious schools from school choice programs as a violation of the free exercise clause? So I thought that was a really great idea. Now I have to say my colleagues thought it might be a little aggressive, but they decided that we would look for some programs. And so we found these programs in Maine and Vermont that were small school choice programs for kids in rural districts and excluded religious schools. So along with another attorney at the Institute for Justice, now retired, named Dick Comer, we sued and challenged the exclusion of religious schools from the town tuitioning program in Maine. So I was the first lawyer 25 years ago to challenge the program that was invalidated on Tuesday, which I might cry. So that's my story. And it's a great, and we lost. many times. Soon,
Actually, I would say that there are many people. It's important to realize, first of all, I think it would be safe to say that for a very long time, there was a whole group of people who would say that that program in Maine, the one in Vermont, they weren't really school choice programs, right? They weren't like the voucher tax credit programs that we knew of. So that's the first thing, is that some people even qualify, that's not real, that's kind of old timey stuff. Those are rural states. And the second thing is, I mean, I wasn't around for it, but I would imagine there were a lot of people who were thinking, you need to stop messing around with this litigation here. It's a fool's errand. Just focus on defending the real school choice programs. Don't deal with these other things out there.
Right. So I think that a lot of people thought we were nuts. I mean, no one, so because it really wasn't clear at the time when I was involved in the Milwaukee litigation, which was the first program to include religious schools, and that we won in the Wisconsin Supreme Court. I was also involved in the litigation that went to that became Zelman versus Simmons Harris, which is the 2002 opinion in the Supreme Court that said that it was constitutional to allow kids in voucher programs to go to religious schools. And a lot of people said, and not unreasonably, you guys are being way too aggressive. Like, just fight one battle at a time. Let's first establish that you can do it before you start monkeying around with whether you must do it. But I think Dick Comer and I, we had this idea, I don't know, we guess we got vindicated 25 years later, whether that made us right or wrong in 1997, that it was in fact good to do both, because there was something kind of offensive about saying to these kids in Maine, look, you can go to Swiss boarding school if you want to. You can go to Andover, Exeter, Choate, but the one thing you can't do is go to the diocesan high school in Portland. You can go to a school that costs $60,000, but not the one that costs $6,000. And so we did lose. Soon after the Maine, we filed that lawsuit in Maine court. I was gone by the time that case wrapped up. We lost in the Maine Supreme Court. And what the Maine Supreme Court said was, well, maybe they'd have to do it if they could do it, but they can't do it because it's unconstitutional to include religious schools in these programs. Other people start suing other organizations. This was another reason it made sense to get involved, because if IJ wasn't going to do it, somebody else would, and they did. There are a whole bunch of litigation. The Maine's program is challenged multiple times. Vermont's program is challenged multiple times, and the litigation is completely unsuccessful for 4 years. A year and a half ago, the Second Circuit invalidated the exclusion of religious schools from Vermont's program. That was an IJ case. And then we get finally to the Supreme Court. But I think John's right to say there's a lot of law, a lot of water under the bridge between 1997 and Tuesday. The first thing that had to be established is that you could do it, that the Constitution permitted kids participating in choice programs to go to religious schools. And once that is established in 2002, for the next 20 years, and we get into the holding in a second, what Maine said is, we know we can do it, we just don't want to. We should be able to have more secularism, more separation between church and state than the federal Constitution requires us to. And that so the path from if you can do it, must you do it, is a 20-year path. And there's a lot of law there and a lot of litigation there. We can talk about that. But I think ultimately we were right. I mean, obviously we're right because we won. But I think that once the court said you can do it, there is a line that was inevitable, perhaps, you must do it, because otherwise what the line is sure you can do it, but if you want to discriminate against those religious people, that's fine. And that stops making sense.
Yeah, I think that, that's I guess if we just start the clock at Zelman, 2002, right? This is the Supreme Court saying that it is permissible for a state to provide public aid for a child to choose a non-public school, including a religious school. If you start the clock there, it's funny because it is almost inevitable that we're at a certain point, we're going to get to the question of once you start, no state has to provide such aid. But once they do, must they allow such aid also to be used in religious schools? I don't know about, I didn't think that it would take 20 years, but maybe I was being naive.
Yeah, so you think about, so when Zelman was decided in 2002, I was on the faculty here, and I have to say, when that case was being litigated, we didn't really know what was going to happen. Everything seemed to come down to Justice O'Connor as it did in those days. So there's a whole bunch of messed up establishment clause law leading up to Zelman, and it's all over the map. Literally, speaking of maps, at one point, the Supreme Court in the 70s or early 80s held that it was okay to provide books for kids in religious schools, but not maps. Because the logic was something like the teacher might point at the Vatican. I mean, the law was such a mess, and the court had been cleaning it up, right?
Did Justice Scalia say, well, then what about atlases?
So the court had slowly been cleaning it up and moving toward what was principle of neutrality, which is that the Establishment Clause doesn't require anything more than the neutral treatment of religious and non-religious providers. So there's a series of cases that go to Zelman that involve little aid, like the sign language interpreter for the deaf child in the Catholic school. That's okay because it's provided to deaf kids, and I mean, deaf kids everywhere. So it's neutral toward religion. So the program in Zelman was a very small, it's now statewide voucher program in Ohio, but it had 5,000 kids and 95% of them went to religious schools, almost all of them Catholic schools. There were a few Lutheran schools that participated. And so it goes up to the Supreme Court. And the question was, well, they allowed kids if they wanted to go to suburban high school, suburban districts, but no district took them. So the question was, is this neutral? Because 95% of these kids are going to religious schools. Is that religion neutral? And the court very importantly said, what matters is that the rule is neutral. This isn't, the constitutionality is not like it's not a demographic scheme.
Neutrality isn't empirical.
It's not an empirical question. Otherwise, school choice might be constitutional in Kansas, but not in Cleveland, right? So once you get that established, I think it is inevitable that you get the rule of neutrality also being applied on the free exercise side. But there are lots of questions left open. An important one that probably is mostly gone now is what happens. All the litigation shifts to state courts. States have their own establishment clauses. State establishment clauses can be more restrictive than federal establishment clause. Many of them actually appear on their face to require religious discrimination. So everybody said, well, Zelman won't mean anything because all these state courts will just invalidate these programs. That actually hasn't happened. But one of the big things about Carson is Carson, together with another case called Espinoza, which we should talk about, makes it clear that states can't say, oh, well, even if the free exercise clause requires us to do this, our constitution won't let us. So we're going to discriminate. We're going to exclude religious schools. So
I think things really start to ratchet up. There are two cases. It's kind of funny. You read the Carson opinion. There's very little conversation about the Constitution. There's not very much conversation about ye old timey days. It's really about two cases that the court comes back to. One is Trinity Lutheran, the other is Espinoza. So I think you really can't understand Carson. What Carson is trying to do is kind of reconcile Trinity Lutheran and Espinoza in the context of these tuition aid programs. So what's going on in those two cases that informs Carson, Trinity Lutheran and Espinoza?
So, right. So Trinity Lutheran is 5 years ago. Espinoza 2 years ago. Trinity Lutheran is a Missouri program that provided recycled tires for playground resurfacing at preschools. Trinity Lutheran has a preschool, church, it applies, and the state says, oh, golly, we'd love to give you these recycled tires, but we can't because you're religious. Our constitution won't let us. So this case is challenged as a free exercise violation, where the court, where the argument here is this is not neutral toward religion at all, right? You're saying you qualify. And the nice thing about Trinity Lutheran is it clearly was like, it must have been like the most important playground resurfacing project in the state of Missouri. Like you qualify in every way for these recycled tires. It goes up to the Supreme Court. The Supreme Court's like, look, this isn't neutral toward religion. The only reason you said no is because this is a religious preschool. I think actually that case was important, and this is contrary to my aggressive stance of 1997, that it was a preschool and it was tires. It wasn't a school choice program. It was just stupid, right? Like, how can it be like required to not give the preschool like recycled tires? The Chief Justice even talks about like scraped knees and things in his opinion. So that case is about recycled tires, but it applies this neutrality principle, basically articulating the principle that comes to play in Carson, which is if you're going to extend a general benefit to private providers, You cannot discriminate against a provider because they're religious. So then 3 years later, this is Espinosa case. Espinosa case is about a school choice program in Montana. Very modest tax credit program. It was worth about $500 each. But the scholarship program had been invalidated by the Montana Supreme Court. And the reason the Montana Supreme Court invalidated the program is they said, well, our Constitution requires religious discrimination. This program includes religious schools, so therefore it's unconstitutional. And the court says, look, what the free exercise clause requires is neutrality. We told you 3 years ago not to behave in a non-neutral way. The only reason you invalidated this program is because you wanted to discriminate. So what you did was unconstitutional discrimination. And those two cases are the foundation of what happens in Carson. Should I say something about the little loophole that needs to be closed?
Yes,
So one of the problems in both of these cases is the Chief Justice is an incrementalist. And so he doesn't like to answer questions that don't need to be answered. So in both of these cases, he says, well, look, both of these, clearly the reason that the discrimination happened is because of the character of the institution being had a religious character. It was a Lutheran preschool, and the schools were excluded because they are religious. And then in a footnote, and then later in the Espinosa opinion, he says, well, we're not saying that it might not be okay to just discriminate if you don't want to spend money on religious stuff, like teaching, education, religious conduct, or belief. So long story short, that is released. He also says, we're not saying it's okay either, but we're just going to leave that out there for now. So Maine's program is getting challenged yet again. It goes up to the First Circuit, and the First Circuit with Justice Souter, who is retired, sitting by designation. Justice Souter is actually on the panel that upholds the Maine program, and they say, oh, well, this program, they're not discriminating against religious schools because they're religious. They're only discriminating against them because they teach religion.
They do religious stuff.
They do religious stuff. Now, y'all are Catholic school teachers, and you know that to be religious is typically to do religious stuff. And so this status use, character use distinction totally falls apart. In fact, one of the fun things I got to do the last couple of years is file 2 briefs for the Religious Liberty Clinic at Notre Dame on behalf of the Partnership for Intercity Education. Some of you may be teaching there, which is a Catholic organization, a Muslim school group and a Jewish school group, and all just to tell the court, like, look, in order to be a Muslim school, you got to kind of teach Islam. Like, you can't, like, to tell us to not teach Islam is to tell us to not be Islamic. So what happens in Carson finally is the court says, Chief Justice, very little law. He says, we never said that. I mean, we never said that was real. Like, we were just, there's no such distinction. It's always bad to discriminate against religion. So like that last little loophole is now closed.
So that was what I wanted to get to. If we talk about the opinion for just a second. So I think there are probably 2 things that are going on in the majority and the dissent that are worth discussing. The first is that I think it would be fair, some may disagree, but it would be fair to not see Carson as significant for what it may be foretelling as it is with regards to what it may be culminating, like kind of that it's foreclosing some things. And so there are a few questions that were left out there, like this status use designation. I would say if you even go back all the way to Everson, there always seemed to be these sort of carve-outs in religion clause jurisprudence where it was kind of like, all right, we'll let you do this unless that happens. And this kind of puts it ties a bow around those. That's the first. And the second thing I'm hoping you can talk about is the dissent puts a lot of attention into establishment clause questions. And Carson has decided on free exercise ground. So maybe just a word about those 2 issues. One, kind of how this is a culmination, and second, kind of what it's doing with regards to the 2 religion clauses.
Right. So I think Carson breaks very little ground in terms of doctrine. And in the way the chief writes the opinion, he sort of says that, like, we've told you this like a lot of times, like this is self-evident. What you're doing is unconstitutional. You should have known that in 1997 when Nicole Garnett filed that lawsuit. We've always said, like, it's sort of like we've always been at war in Eurasia. We've always said that the Constitution demands neutrality toward religion. As John points out, in a sense, that's true. But they would say, like, there are lots of opinions that were sloppy that suggested sometimes it demanded hostility toward religion. So in this sense, what Carson makes clear, I think, and it leaves open other questions that we should probably talk about. Look, the First Amendment's Establishment Clause requires neutrality toward religion, but the First Amendment's Free Exercise Clause does too. And just as you may include religious schools in a generally applicable religion neutral school choice program, you may not exclude them for the same reason. Those are both non-neutral. So if the program is singling out religious believers or religious institutions for disfavor, then it's unconstitutional. And I think what Carson, there will be more shenanigans, no doubt, in the lower courts, but Carson really does make that crystal clear. There are no excuses for religious discrimination. You may not, there are other questions, but we mean it this time. You may not, there are no justifications. The status use thing, the court says isn't real. The other funny thing about, it's actually worth listening to the oral argument because the main lawyer was not an effective advocate, but he says they kept arguing that, like, well, the other reason we're doing this is we want to replicate a Maine public education for these kids in rural districts. Justice Alito says, are you telling me that Andover replicates a Swiss boarding school replicates a Maine public education? And the guy says, yes. He said, how? He said, it's secular. At which point Justice Alito in exasperation says, so you're telling me the only thing that is critical to a Maine public education is it's secular. That's what makes it Maine public education, justices. And the guy goes, yes. Okay, well, so, I mean, the guy lost, was gonna lose. But yeah, so I think that it closes these loopholes. It's clear that neutrality, and there is going to be a lot of litigation, and probably not in voucher cases, but in other public aid cases. There are a lot of programs out there that say to Catholic charities, you could do job training, but you can't do it in a religious way. You can provide homeless shelters, but not if it's religious. I mean, you could be religious and do it. But, so there's a lot of litigation that is out there. And what was the other question?
So the second was it's the establishment clause. It's this kind of every I was going to say law student, but anyone who's taken high school civics or a political science course, there's always this key question. Well, if the free exercise clause on some level is about accommodation, right? Like permitting space for the exercise of religion. But if you really think about that, wouldn't every single accommodation itself be an establishment? So does the whole thing just fall apart on its own? And that's a very kind of blunt summary of, I think, some of what's going on in the dissent is kind of, well, this has to violate the establishment clause.
Yeah, so the dissents are sort of like, they're just, sky is falling. I mean, Justice Sotomayor is very upset about the crumbling of the wall of separation. Justice Breyer seems to think we're soon to descend into religious warfare because 30,000 kids in Maine can get $10,000 to go to a Catholic school if they want to. And so there is this sort of hand-wringing, and if you read the press, this is all about, separation and how bad this is. The first thing to keep in mind is this case, the Establishment Clause had nothing to do with it. It was not an establishment case ever, because it was never in question that Maine could send those kids to religious schools if it wanted to. So there's this sort of, I think it's almost like a resuscitation of old arguments about the establishment questions. I mean, Justice Breyer talks a lot about, quote, unquote, the play in the joints. So is it possible for the states to have a little room to discriminate if they want to be more secular? Because, maybe Alabama wants to be not secular, but Maine wants to be more secular. And he seems to think this is really bad, that this is eliminating the play in the joints. I do think there are lots of other questions that are left open. One is you're right. I mean, lots of accommodations of religion exist. So are those not neutral toward religion? The court has said those are constitutional, but I think those questions are like, if, and this gets into a bigger free exercise problem, but if all that the free exercise clause means is just be neutral, lots of regulations burden religion are fine. And some regulations, maybe, that privilege religion are not. So those questions are not answered at all in Carson.
So let's take a second, and then we want to hear what kind of questions we have out there to talk. Okay, so what does this mean moving forward? So maybe as a framing device, what is most likely to happen, do you think, in the state of Maine, given this opinion? And then furthermore, more broadly, at least I think a word on what you think is most likely to happen, maybe not necessarily because of Carson, perhaps to some degree, but with regards to like regulatory strings for these kinds of programs.
So most likely to happen in the state of Maine is they will stop tuitioning.
Just shut the program.
They've said they don't want to do it, and they don't have to. The court says clearly you do not have to have private school choice in the state of Maine. It just, if you're going to do it, you can't do it in a discriminatory way. Now, whether or not those 3,000 beneficiaries are going to kick and scream loud enough to be able to maintain, I mean, there will be more tuition kids if Maine keeps tuitioning, because I mean, the money's not that much and the parents have to top it off. So most of the schools that these kids are going to are super expensive and regular people can't afford them even with the voucher. But Maine might just stop, and that might happen. So I do think it has, so I think the most important thing to keep in mind about the groundbreaking nature of Carson isn't its immediate implications, but just to remember that the court on Tuesday vindicated a position that our church has been taking since at least 1842, when Dagger John Hughes, the first Archbishop of New York, demanded funding for kids in Catholic schools on equality grounds, because he said the public schools are Protestant and they are beating our kids for not reciting from the King James Bible. They're hostile to Catholic kids. We're doing a good job. So in some sense, it's like monumental. Like, it's this incredible victory for religious liberty and a position of all the Catholic schools have ever demanded is fair treatment. And so we won. That's awesome. Immediately, the implications for school choice are minimal, except for Maine and Vermont. The 31 states which have school choice all include religious schools, because choice makes no sense without them. They're good and they're cheap, and they serve, and parents want them. So why not include them? But I think longer term, it does open the door for further expansion of parental choice, because it takes away the Blaine Amendment bogeyman. It raises the question of charter schools, how do you apply the non-discrimination principle to charter school statutes? That's the next big legal question. Charter school statutes all require charter schools to be secular, and they're privately operated. That actually gets into the weeds in a way that I don't know if you want to talk about off camera. Something I think a lot about. And so then what doesn't it answer? I mean, I think the biggest question it doesn't answer is that it doesn't say anything about the conditions that states can put on the receipt of public funds. So far, there are very few burdensome restrictions on the receipt of public funds in these states. I mean, most voucher and tax credit programs don't even require you to take the state test. Minimal, no certified teachers, no curricular requirements really. So the question, and I really do think the non-discrimination things are the first. So can the state of whatever, Maryland or Ohio, Maryland's the only one who's done it, condition the participation in these programs on hiring restrictions for teachers that the Catholic Church objects to on religious grounds? That is a really hard legal question. That is because as long as the rule is applied across the board to all schools, you can't make the case that it's not neutral. Yeah. So then this is where the neutrality principle only gets you so much protection. There's another whole fight in the religious liberty world about whether neutral rules that burden religion are unconstitutional. Thus far, the Supreme Court has said they are not, but in a case a couple of years ago, there was a kind of nod toward a majority thinking maybe that they might change their minds. So that's actually, I think, one of the biggest questions is what are charter schools, and then what are the conditions that can be constitutionally imposed? Yeah,
I mean, now that, so Maine has to include religious schools, it also can choose to regulate them in all sorts of ways. I mean, it's gonna ratchet up.
It's particularly important because the Supreme Court has said that in a couple of important cases that religious schools have the right, religious organizations, including schools, have an absolute right to pick their ministers, and has defined ministers broadly to include at least every teacher who touches religion. And that's a major free exercise protection for religious institutions. But then the question is, well, could Maine say, sure, but you have to waive that protection? Like you don't get it's called the ministerial exception. You don't get that anymore. That's going to keep lawyers busy for a long time. And I think some lawyers will start challenging charter school laws. And then the big bread and butter of this is not in choice at all. It's not education at all. It's all these social service programs.
Yeah. So should we open it up for questions? What questions you all have, and then would you?
Yeah, I'll monitor.
Okay, great, thanks. Questions? You all?
I have a pretty simple, just kind of clarifying question. Can you speak to a like explicit example of a neutral rule that burdens religion? That's just something that's new to me.
Oh, all hospitals must perform abortions. I mean, because the Biden administration's probably maybe today or within a month will require Catholic hospitals, all hospitals to perform abortions. That's religion neutral. Everybody has to do it. In order to participate in Medicaid and Medicare, you must perform abortions. And so that's a religion neutral rule that burdens religion. Thanks.
Other questions? Yes, there's a whole body of law on that that's really fun, where you get into things like animal sacrifice and peyote and all sorts of other.
So on that, I mean, one thing that's really interesting is that this is getting off topic a little bit, is what the Supreme Court has been doing over and over again in those burden cases is saying, well, actually, this isn't neutral. So, so this happened in the COVID context. So for example, New York had a law that said all places of worship during COVID could only have 25% capacity. I can't remember exactly the rule, but you could go to the grocery store, or you could go to the bowling alley, or you could go to the movie theater. And so what the court would say is, well, this isn't neutral toward religion because it's burdening more religious institutions than it is burdening, not religious institutions. And so they've done that in a number of cases. So they've kind of, they skirt the issue by just saying, well, if there are any exceptions to the rule, then it's not neutral. And so therefore it's subject to more scrutiny.
So the tricky area then is to like have to think about religion in order to form something that's truly neutral in a way.
So, yeah, I mean, I think that the trick for the regulation wise, I mean, you have to think like sometimes there might be good reasons for exceptions, right? So, but if you're the regulator, you're the lawmaker, you have to think, well, if I make this exception, is that going to, make this regulation subject? It's really about the level of scrutiny, how hard the court is going to look at it. So that's the question of how many regulations are actually religion neutral is something else that gets litigated all the time.
That's interesting. Thank you.
So could another maybe unwanted consequence be something like, yes, you can get state dollars, but your teachers all have to be licensed or something along those lines?
Sure. I mean, I don't see that. I think that's perfectly constitutional. I mean, so I think it's always important to remember that most of these battles are political battles and not legal ones. The law can't save us all. So, I mean, school choice has been lightly regulated, and parental choice advocates have been pretty successful at fighting back even minimal regulations, whether that's politically wise or not. But I don't think there's, if the law said, in order to participate in this voucher program, you must hire certified teachers. Unless there's an exception, then I don't see why it's a hard case to make.
So I mean, one way to think about this is the United States is just so distinctive in the international context with regards to how we draw lines in the K-12 education sector. So for the most part, up until 1990, there were two kinds of schools in the United States. There were public schools and there were private schools. And you would say, well, what makes a public school public is, one, they cannot discriminate in terms of who they admit. They have to admit everybody. Two, they get public funding. And three, which doesn't really matter for the person, well, kind of, I guess, given what you just asked. Three would be that their employees are state actors. Right. But the minute in 1990 that the state of Wisconsin starts providing public dollars for children to attend schools that were once considered private, now it's kind of like, okay, well, is that still a solid line there? Or now is it a chain link fence? Then, whatever, 7-8 months later, the state of Minnesota enacts the first charter school legislation. Now you have publicly funded, privately operated schools. Now it's unclear whether, whatever those mesh fences are that they have like in ski or whatever those, but you know, those orange.
Chicken wire.
You chicken wire. It's unclear what this really is. So the question that you're asking, it kind of cuts to, it gets even, it's at a higher level. It's kind of like, well, if the state is going to choose to provide funding for schools other than the schools it operates, can it regulate those schools more? Yes, of course, right? It can. The fact that it hasn't, that's just a political issue. And I think for the most part, for the better part of more than 200 years, private schools, in particular Catholic schools, really have not been like closely regulated. They've been quite independent. If you think about it in the United States, we've had this very strange thing where Catholic schools have gotten no money, essentially, but also very little regulation. Well, the minute that the money starts coming, it's just a natural consequence.
But it's, just keep in mind, I think it's a political consequence, not a legal one. I mean, Carson doesn't mean that the state of Indiana needs to slap new regulations on schools participating in the school choice program. There's nothing, they can do as much or as little regulation. It just becomes rhetorically, well, you're getting this money and you're not getting regulated. I mean, one gift of, honestly, that having to go it alone for so long, I think, is the autonomy that Catholic schools and private schools have enjoyed in the United States. The Irish and British and Scottish people, I don't know if you were able to meet the heads of these, the Irish Catholic schools, English in Wales and Scotland were here. We met with them, and I was fascinated, in Scotland, and this is true in a lot of countries, Scotland, all Catholic schools are fully publicly funded, which sounds great, except their teachers are state employees, and they have no power over picking them, except that they may say the principal and head teacher may be Catholic, but they're not allowed to scrutinize the claim that the principal and head teacher may be Catholic. So like in some sense, they have all the money in the world, but they don't have any of the freedom. And I've been doing a little more international work. Like John says, we are an outlier in not funding faith-based schools in the United States, but you do see this, we're so obsessed about money because we don't get it. In other countries, they're so worried that they have no freedom at all to regulate. They have a strict curriculum requirement. They can't dismiss students. They can't charge tuition. They can't pick their teachers. So, like in some ways, I think the school choice movement comes at a nice point because private schools here are not regulated and are going to fight to remain autonomous. And hopefully we'll continue to get money, but in other places they get lots of money, but they have no freedom, and it's a problem, I think, for Catholic character.
Yeah, so just to go along this line again, so if ministerial exception is going to be a battleground going forward potentially, what are the issues around what's important to think about in terms of, is a math teacher at a Catholic school a minister?
It's a great question. Yeah. So the ministerial exception is it's actually pretty well established that is a right, that you get to, religious organizations get to pick their teachers and free of all scrutiny. But there's a couple things. The first is that what I was flagging is whether the state could condition the receipt of public funds on waiving it. But what you point out is that there's a whole bunch of litigation going on right now about who a minister is, or what roles a minister, which roles in the school a minister plays. And the court has been, John's read these cases too. It's been pretty capacious in its definition. Like, it doesn't have to be a co-religionist. It doesn't have to be the entirety of the teaching of the minister, of the employee. So not just theology teachers. Like, one was a fifth grade Catholic school teacher who taught a little bit of religion. But yeah, what about the math teacher? What if, and also there's all these, most dioceses now require you to sign a statement of faith. What if the contract says everybody in the building's a minister and you all have to start class with prayer? Is that enough?
There's a kind of a baseline question to this that I think is very, very interesting. And I'm not making a normative claim on this, but so think of it this way, right? So if the question is who's a minister, right? There's a previous question. Who gets to decide who a minister is? Because if the government, one way to look at it would be, if the government is telling you who qualifies as a minister, is that not an establishment of religion? So, I mean, you take it even, one way to look at it is to just say, the only entity that can decide who the ministers are in a given faith is the faith itself. You get to a very different place than if you start saying, all right, well, the federal government is going to lay out the qualifications for being a minister in the educational context.
That would be unconstitutional. But I think, so yeah, so there is a whole bunch of other law, like it's a broader church autonomy doctrine that goes into this. But the one thing courts don't like to do is say like that religious leaders are wrong or that something is required by the Catholic Church or not. I mean, there's litigation in Indianapolis right now about the bishop firing a teacher for marrying a man who married a man. And then the bishop told the school, like, if you don't fire this guy, you're not a Catholic school anymore. And the teacher sued. And under the church autonomy, that's not really a ministerial exception case, but under the church autonomy doctrine, the court, I mean, we'll see, but it's in the Indiana Supreme Court. The doctrine would suggest the bishop gets to say what's Catholic, right? And in the same sense, I think that you could make the argument that the bishop gets to say what's a minister. There's another case in the Seventh Circuit, also an Indiana case, about a school counselor. And she says, I'm not a minister. Unfortunately for her, she had previously claimed that she was, like, loudly, but so she's probably not going to win. Bad facts for her, but yeah. So that's kind of the, you know, to what extent will the courts look under the hood at claims that everybody's a minister in the building? I think if I were their lawyer, and I would think this in particular, not just in the Catholic Church, but in other contexts, you should, you know, churches and this is not just teachers, it's like janitors and the choir director. I mean, you want to be careful not to overclaim. Like if you're just being smart, you don't say that everybody in the building, including like the night janitor, is a minister, which some religious institutions want to say, and they might win, but they might lose. And you don't want to, like, I think you need to think it's a functional test. Is this person actually charged with teaching the faith in some way? And the math teacher surely could be. The night janitor who never sees a kid probably can't. So you don't want to overclaim. It's just prudence.
Yeah, somewhat related question. So when you said the wall between being religious and doing religious things falls, how does that apply to like grant programs? I know we participate in some at ACE, but inherently they're funding religious instruction with this decision. States will fund religious instruction because they're funding religious schools. So would that apply at a more micro level? Will they have to fund religious instruction and not discriminate from, say, a religion teacher versus a math teacher in a Catholic school?
Well, so it strikes me, so the religion teacher is really particularly complicated because of a different case, but your question, which is, you know, it's about AmeriCorps, is the question about these programs, right? So I mean, Sister Kathleen's nodding because she knows about all these restrictions that get put on these funds, but I mean, not just in education context, but if the program says you can get money unless you're a pervasively religious organization, because the pervasive religious restrictions tend to be about not teaching religion, not doing religion. What if the program, that's probably out now, right? What if the program says you can get money if you are a pervasively religious organization, as long as you promise not to spend the money on religious stuff? That's one step away from Carson, but it's pretty suspect. I had a student a couple of years ago write about the New York City's universal pre-K program, which says you participate if you're Catholic, but you can't teach religion. So you would have these weird like secular preschools in the basement, and then the rest of the school would be Catholic. I think that's actually probably not constitutional after Carson. But your question is a great one. It's not just about y'all. It's about hundreds, if not thousands, of restrictions on spending. I can guarantee you there's some unfortunate intern at the Beckett Fund for Religious Liberty who is right now has stacks, the equivalent of stacks of federal regulation books going through and trying to make a complete list of these kinds of restrictions.
I want to make sure just to clarify, I don't think this is necessarily what you were asking, but just in case, it's important to distinguish with regard to these. Again, Maine is distinctive, but if you take the 31 family choice programs that are out there, the state aid that is appropriated is not for private school instruction. Right? It is essentially a scholarship. So it is the state of Indiana saying, we will make available X amount of dollars for every child whose family is at or below a certain level. That family can use those dollars at a private school, regardless of whether it is secular or religious. So the kind of circuit breaker, as some people will kind of distinguish it or determine is that this is indirect aid. So long as there are both secular and religious options out there, the state is making no claim as to whether it's prioritizing or preferencing religious instruction. You're asking a little bit of a different question, but I think that is a key element of the Establishment Clause doctrine, is what's called indirect aid or intervening private choice.
And the court sort of says that it was like a throwaway about Zelman in the Carson case. I think it's interesting, though. It's a good question. I mean, this is another hanging chat after Carson, is to what extent that matters anymore.
Sure.
Because the aid in Trinity Lutheran, those tires, that wasn't an indirect aid. They were just giving tires to the preschool. Do you know that? I mean, billions of dollars went to Catholic schools in COVID directly. Yeah. And the PPE stuff, all that stuff, that was all direct aid, and no one blinked, no one sued. So, and there in these cases, the court has sometimes it hasn't said that it doesn't matter anymore, but it's ignored the fact that, you know, in cases it said it's unconstitutional, like Trinity Lutheran, where there was no circuit breaker. It was just, if you're a preschool, you can apply for tires. I think there's some questions out there.
We have a couple over here.
Yeah.
So one asks, there are a number of dioceses facing difficult choices of what to do with lower income Catholic schools facing closure. Because of Carson, are there specific state contexts where you would recommend dioceses begin applying for charter school authorizers? Could you imagine a two-tier system of school accountability regulation between religious charters and private school choice programs?
No one's thought more about this than
Yeah, you can call me. So the charter school question is a complicated one, and the main question has nothing to do with religion. It's actually, is a charter school a state actor? Is it a public school? Because that's what the state laws say it is. Is it a private school because it's privately operated, lightly regulated? Federal courts are divided on this question. In fact, there's just a decision about a charter schools in North Carolina, say the Fourth Circuit, are government schools or state actors. That case had to do with uniform skirts, not religion. But the Ninth Circuit said the other thing. So yeah, so to your second question, is there a two-tiered system? I don't know that religious schools should decide to become charter schools. And I think those that do should go in recognizing that there will be more tightly regulated, including having to answer to charter school authorizers that Catholic schools do not. So, you know, read your regulations, charter school regulations. Are there places, if you're thinking about this, to start? Yeah, there are certain aspects of charter school laws that I think make it less likely that a court can find charter schools to be government actors, and they're complicated. One is multiple authorizers, including private authorizers. Minnesota, for example, in Minnesota, the St. Thomas Catholic University is a charter school authorizer. It can authorize charter schools, but the charter schools can't be religious. It's a pervasively religious college. In Ohio, there's a charter school authorizer called the St. Aloysius Orphanage. I don't even know what that is. It's not an orphanage, but it authorizes like 40 charter schools. So I do think where you think about this has to do with the regulatory landscape, what the law says, and what the courts are likely to respond, because some states might be more friendly than others.
I also think that, I know there are other questions, but I also think that the current political and legislative context in the state matters a lot, because if there is any reasonable chance that you can get authentic insofar as we've known it, private school choice, like what we have in Indiana, it is probably better to try to get that type of program than to use this charter school mechanism, if for no other reason than that it's just better known. We know what's coming. I understand in places like my home state of New York or yours, Jessica, California, that's a heavy lift. That's a long road to hoe. But I think it really, really matters where we're talking about, because you know, let's put it this way, right? So if we were having this conversation and per pupil charter school funding was the exact as private school choice funding, then I would imagine most people would say, yes, of course, you go with traditional private school choice funding. You don't go the charter route. So anyway, I think that matters a lot.
Yeah, a couple things. I think John's totally right. So first of all, I'm an egghead, and I have nothing better to do than think hard about whether charter schools are government schools or private schools. But I mean, there's a lot of prudential judgment that goes into this, and I think making prudential smart judgments are important. I've had lawyers call me and ask me like, should we sue and challenge X law? And I'm like, no, don't start there. You will lose. Then, I mean, the other thing is to keep in mind, when I'm talking about religious charter schools, I mean really religious charter schools, like not wraparounds, like with religion in the basement on Fridays, like literally that they are able to be religious charter schools. I think it is going to be the next litigation battle. But I think it's also one thing to keep in mind if you're thinking about that route. It's a kick in an anthill, like you won't believe. And the charter school folks don't want it, and they want to be public. And that's what happened in North Carolina. The charter school folks said, no, please, we're public schools, regulate us. We want skirts to be banned. And I think, so you don't want to, you need to think prudentially, politically, legally. What are you getting yourself into? What are the second and third tier consequences?
Maybe one more from over here. So thinking about Trinity Lutheran, Espinoza, and now Carson, how do they have an impact on an effort to take down Blaine amendments? How close are we, and what sort of cases need to come before the court in order to make a change in Blaine amendments?
So these cases make clear that you may not rely on your Blaine Amendment to invalidate a program because it includes religious schools, or to exclude a program, religious schools, from participating. So in many ways, they've taken down the Blaine Amendments in a lot. I mean, like they've defanged them. So sometimes they say like it invalidated the Blaine Amendment. Maine didn't actually have a Blaine Amendment. It doesn't even have an establishment clause, but Espinoza, Montana did, Missouri did. But it hasn't invalidated them. It's just made it impossible to apply them in many states. Some states' Blaine amendments are still enforceable. If your Blaine amendment says no aid to private schools, including secular and religious, that's religion neutral. So Michigan, Massachusetts, others, I think, then you would actually have to show, and it'd be much harder, that it was religion, that the motivation was that the amendment was enacted because of anti-Catholic animus or something. And I don't see courts going for that argument. Oh, there has been some litigation, including some ongoing litigation about that question.
Oh, sorry. So, okay. So I'm getting a signal here that we should try to wrap up. Thank you all very much for being here. Thanks to the folks who joined us online. It's just great to meet you. Thanks, everybody.
That's all right.
Thank you.